You're listening to a special edition of We Get Work, recorded live from Workplace Horizons 2025 in New York City, Jackson Lewis's annual labor and employment law conference. Over 500 representatives from 260 companies gathered together to share valuable insights and best practices on workplace law issues impacting their business today. Here's your personal invitation to get the insights from the conference delivered directly to you. We'll see you in 2026. Good afternoon and welcome to We Get Work live from Workplace Horizons 2025. This afternoon, I have the pleasure to have in the podcast studio Tanya Mistretta, a principal in the New York City office of Jackson Lewis, and Michelle Phillips, a principal in the White Plains office of Jackson Lewis. What I'm first going to ask you, so you can tell our listeners, is a little bit about your practice, what you do, and really what clients are asking about right now. Tanya?
Sure. Good afternoon. So I do a little bit of everything. I do advice and counsel, I do litigation, I do training, and a big component of my practice is in the disability leave health management space. So today it was such a privilege to be able to speak to the group on Title VII, ADA, and Pregnant Workers Fairness Act accommodation issues. These are a lot of the topics we get questions on from clients. And in the current climate, a lot is changing. And so a big part of our presentation today was talking about what do we see on the horizon and how do Title VII and disability accommodation and pregnancy accommodation issues overlap and interplay with one another. So I spent a lot of time advising clients in that space. And unfortunately, sometimes I also litigate in that space. But yeah, that's pretty much the long and short of it.
All right, terrific. And Michelle, how about you?
Yeah, it was great co-presenting with you. Really, I learned a lot. Like I was listening to you actually when you were, I was like, wow, I didn't know that. So that was very cool. And, in my area, I similar to Tanya, I do a lot of litigation. I do a lot of advice and counsel. I do a ton of training. But it's on a kind of a wide variety of issues. But I think if I'm to sort of subspecialize, I had been doing a lot of work in the DEI space, and that's really, talk about change. That's very much changed. And so it's not so much dismantling DEI as much as being more careful around the guardrails and being more legal and thoughtful about your efforts.
So your title of your presentation today was exactly that, from ADA to Title VII, trending issues in, and here's the key word, accommodating employees. And I know Catherine Weber's not here to share the stage with us this afternoon, but what else did you cover this afternoon in your presentation?
Sure. So I took lead in terms of the Pregnant Workers Fairness Act, and I talked about sort of what we expect from the EEOC, what we may come to expect if the administration follows Project 2025, and some of the common issues that do come up, particularly with respect to the issue of abortion and religious accommodation and religious objection. So this is the beauty of coming to a conference like this. Like, I feel like I learned so much from Michelle and Catherine because Michelle deals with Title VII issues so often, and she was sort of like the resident expert on that topic. So I'll let Michelle speak to her experience with that. Yeah, it was really covering what sort of hot button issues do we see, what questions come up frequently, what are the guardrails, and what do we expect on the horizon in sort of navigating the overlap between these types of accommodations.
Yeah. So it will not be surprising if I were to say that a lot of people talked this afternoon and yesterday, as we've been talking to the thought leaders here at Jackson Lewis, about how much change has taken place. And I know it's a very, it came up in your presentation as well as you cross all those multi sort of disciplinary legal areas. So how do you advise people? What are some of the key takeaways that you can share that you shared with the audience and that our podcast listeners want to know?
It's important to be balancing competing interests. I mean, I think in the past, depending upon where you might fall, maybe an employer might favor the rights of one group over the rights of another group. But when it comes to religious accommodation, you have to take it at face value. You can't have an opinion about an opinion. Like, someone may have a religious belief that's different from your own, but you still have to, don't question the veracity or the sincerity, which is the standard of the religious belief. take it as that is their belief, and then decide, well, how can I try and accommodate that belief as long as it doesn't cause a significant cost to other individuals? Like it might bother other individuals, but if as long as the person is not, for example, forcing their beliefs on someone else, you do have to try and be more creative and think of ways as an employer to take into account, because I think we're going to see a rise in religious accommodation claims. And so I think it's going to become, it used to be a de minimis burden, so it was very easy to just not credit it. But because of the change in standard in GRAF in 2023, it's going to take more for an employer to deny a religious request. So I think that's probably the biggest takeaway.
What would you say, Tanya, to that question?
Yeah, I think accommodations, whether it's under Title VII or the ADA or Pregnant Workers Fairness Act, they're very emotional for people. And so what I find is sort of consistent across the board is taking a common sense approach. If you have an accommodation request from an employee and you're sitting there asking yourself, I don't understand it, right? I don't really understand the basis for it. I don't understand why this is necessary as opposed to some alternative. Common sense should dictate here. Have the follow-up conversation. I find some employers are very eager to sort of paper a file and everything, be back and forth by email. And I find that common sense of just picking up a phone and speaking with an employee is really the best way to better understand what it is that they're seeking, and to have that sort of not tone deafness that can sometimes come across through email, but to have that conversation in real time, being sensitive to the basis of the request is really the best way to approach accommodation issues.
Tanya, how are Jackson Lewis attorneys, Michelle, Catherine, yourself, your colleagues, how are they helping our employers, our clients, handle these really challenging issues this year?
Yeah, so I think it's a lot of education and prevention, right? Being proactive. The law, particularly in employment law, is constantly evolving. So we try and do our best to make sure that our clients are aware of upcoming changes and not being reactive, but more so proactive, so we can get ahead of the bell curve and let clients know what sort of issues they may come to expect. So when they get those asks from employees, they already have the answer at their fingertips. And of course, if something new does come up, we're always happy to handle that as well.
Okay. Michelle, you and I have sat across this table many a year now. What would you say is really special about being at Workplace Horizons? How does that also help our clients year in and year out?
Well, I remember going to my first Workplace Horizons. It's so long ago, I don't even remember. It's at least 2 decades ago. It's a while. And I remember feeling like this tremendous sense of awe of all the talent that was in the room. Like I couldn't believe that we had an expert in almost every topic you could possibly imagine under the sun. I didn't even know there were that many topics in employment law, let alone that we had the expert on it. And I think just going from that to today, where a lot of my practice is national. So I may be assisting a client, in California or Indiana or Pennsylvania, and I don't see them ever other than when I'm at this conference. So it's a tremendous way for a lot of us who have a national practice to connect with clients that otherwise we'd just be on the phone or by email. And it's like almost like a coming home when we come together at these conferences.
Michelle, Tanya, thank you so much for participating today, not only here in the podcast studio, but of course through your presentation. And I look forward to seeing you at our next Workplace Horizons. Enjoy the rest of the conference.
Thank you.
Thank you for listening to Jackson Lewis's podcast, We Get Work. Focused solely on workplace issues, it is our job to help employers develop proactive strategies, strong policies, and business-oriented solutions to cultivate a workforce that is engaged and stable. Please tune into our next program, where we will continue to tell you not only what's legal, but what is effective. We Get Work is available to stream and subscribe on your streaming platform of choice, including Apple Podcasts, Spotify, and YouTube. For more information on today's topic, our presenters, and other Jackson Lewis resources, visit jacksonlewis.com. As a reminder, this material is provided for informational purposes only. It is not intended to constitute legal advice, nor does it create a client-lawyer relationship between Jackson Lewis and any recipient.